Hi, my name is Sarah Lipka. I'm an attorney with Colorado Legal Services. This recording is part of a series of recordings about civil protection orders. This is a collaborative project put on by Colorado Legal Services and TESA. In this video, I will talk with you about the steps that you need to take to obtain a permanent protection order. First, let's talk about overall logistics. You'll need to go to your local courthouse to request help. In El Paso County, the courthouse is located at 270 South Tejon Street in Colorado Springs. Here's the court website, courts.state.co.us, which has a lot of helpful information. You can look up your court address by simply finding your county. Let's just pick one. And then scroll to the home page, the bottom of the home page, and you'll find the address for the courthouse in your area. There are some forms that you'll need to complete when you're requesting help with a protection order, and the clerk will give you those forms for free. You can also find those forms here on the self-help section. Just scroll down to protection orders, and they're right there. But don't worry, the clerk will give you a copy of those as well. There's no charge to file a protection order based on domestic violence, so you won't need to pay to ask for help in a DV protection order. Each courthouse has a slightly different schedule. All cases need to be filed by a certain time to be heard by a judge that day. In El Paso County, the paperwork needs to be filed by 9:30 in the morning. The time is different in each jurisdiction. You should go to court first thing in the morning. It will take time to fill out the paperwork. Sometimes there are lines to get into the courthouse. I would try to get to court by 8 in the morning if possible. If you miss the daily filing deadline, that's okay. The court will still hear your case as soon as they are scheduled to hear protection orders again. Courts must make requests for protection orders a high priority, so these cases are heard frequently and often daily in larger jurisdictions. So you made it to the courthouse. What happens from there? You'll fill out the pleadings. So please see the video about completing the paperwork for information about that step. Then you'll file the pleadings, which just means that you hand them to the clerk. The clerk will stamp them and give you a copy. Then the clerk will tell you about an ex parte hearing, where you will need to go to a courtroom at a certain time to see the judge. Ex parte means with respect to or in the interest of one side only. And so that means that you'll be there, but the other side will not be there. And this only happens because it's an emergency. Each judicial officer does things a little bit differently, but when you see the judge or the magistrate, they will have read your complaint. The judge will need to find that you're in imminent danger to grant your request. The judge may ask you some questions about your complaint, or he or she may rely only on what you've written. If it's granted, you'll be given a temporary protection order. It's good practice to double check and make sure that the protection order is accurate, that the birthdays are correct and the names are spelled the right way, because it's really hard to correct it once you leave the courtroom. Although most of the time, the protection orders are done correctly, as the clerks are very good at making sure that it's complete and accurate. Now that you have your temporary protection order, the next step is personal service upon the restrained party. There is no cost for the sheriff to complete service in a domestic violence civil protection order, and most sheriffs do not charge for elder abuse service either. You must have the complaint and the protection order served, both of them, in order for it to be complete and correct service. I strongly recommend that you have the sheriff complete service. They will do it the right way. You cannot do it yourself because you're a party in the case, and you want to have someone do it who's trained to do it the right way. There is no cost for the sheriff to do this, so I would start by asking them for help, and I would go straight to the sheriff's office from the courtroom. Keep a copy of the protection order with you at all times. If the opposing party has not been served yet, then keep an extra service packet with you. If the opposing party shows up before service has been completed, you can call the police, and the police can have him served with the extra copy that you have. If you need service done immediately, for example, you need to be able to return to your home and have service completed before that time, tell the sheriff and see if to let them know to see if they can work with you to try to get service done quickly. Once service is completed, you really need to get the proof of service and bring it with you the next time that you go to court. Sometimes the sheriff will just mail a copy into the courthouse, but you can also call and get a copy yourself. If you don't have proof of service and you have court coming up like the next day or in the next few days, then you can go ahead and call the Civil Division of the Sheriff's Department the day before court and ask for an update. If you do not have service by the next court date, that's okay. Go to court and ask for more time. The judge will probably give you more time if you can explain that you're trying in good faith to have the other side served. But remember, the protection order does not take effect until service has been completed. The other party must be served before they know that they are required to stay away from you. After you've completed service, the next step is a return hearing. You will have a court date scheduled about 2 weeks after that first time that you go to court. If you don't go back to court for this return hearing, the temporary protection order will be dismissed, which means that you may be able to file again if you need to, based on the same facts, but you have to start all over again. What happens at the second court hearing? A few things could happen. If you do not have service, simply get a new temporary protection order with a new return date and work on service. If you have proof of service and the other side does not appear, you can get a permanent protection order. If the other side appears, a few things can happen. The opposing party may agree to a permanent protection order, or the parties can agree to continue the temporary protection order for up to 1 year, only if both parties agree and the court approves. Or you can have a hearing for a permanent protection order. You can proceed to a hearing on a permanent protection order that day if both sides are ready. However, after service is completed, each side gets 1 2-week continuance for good cause before going forward with a hearing. Examples of good cause include that you need time to get an attorney, or you need time to gather your exhibits, or you need time to bring witnesses with you to court. Please see the video about contested hearings for information about how to represent yourself in those hearings. At this return hearing, the restrained party may ask for time to get their things from the home. The court usually gives parties at least 1 keep the peace or civil standby. This means that the restrained party would schedule a time with local law enforcement and the protected party to go to the home with the police there to get their things. A few other practical things to keep in mind as you go through this process. Most judicial districts have court care, so you can still go to court if you don't have anyone to watch the children. Call ahead to find out how to access that service. Secondly, please be sure to keep a copy of the temporary protection order or the permanent protection order with you at all times, and then give a copy to anyone else that needs it for safety purposes, for example, work, school, or daycare. And please see the safety planning video for more information about that. Thank you.